Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. We hope today's webinar will leave you with not just a greater understanding of wills, trusts, and the most basic but essential pieces of every estate plan, but with some peace of mind knowing that in such crazy times, you still do have options and the ability to make a good plan for your future. Before I pass the torch to Bob, I'd like to cover a few housekeeping details. First and foremost, quick disclaimer, and Bob will actually cover this later, but just to remind you that today's webinar is going to be informational. You'll definitely learn some things and you can ask questions, but this does not count as legal advice. If you do have the need for legal advice, I encourage you to contact us after the webinar. Also, today's webinar is recorded. We will send out a replay after this week. Later this week, tomorrow, in fact, that you can watch and share with family and friends. Also, be sure to leave any questions that you have today in the chat box. We will be sure to leave time at the end of today's webinar for questions. So, don't be shy. Please put those questions in the chat box. Now, why should you listen to the folks at Mannor Law Group and what we have to say? So first, we're a nationally recognized and respected elder law and estate planning firm. Also, all three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's also one of only 19 attorneys in Michigan to achieve this designation. He's currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section, and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, Mannor Law Group is honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row, and we're pretty excited about that. Now, without further ado, I'd like to welcome attorney Bob Mannor.
Hi, folks. We're going to get right started here. So there's the topic today is just covering the basics. What are the basic estate planning documents that you need, and make sure that you have set for your family. And so this is the agenda for today. Why you need to know this stuff, and the importance of why it's not just about stuff. Okay, when we're talking about estate planning, it's not just about the dollars. It's just not about your bank account. It's not even just about your house. It's about your life. It's about there's going to be some lifetime documents that are going to be important. A lot of times we really focus on just what's going to happen to the money. Well, money's important and money's an aspect of it, but there's a lot of things involved in estate planning that are much bigger than that, like making sure that we're protecting our family and protecting ourselves, and have things in place for medical decision making and all those types of things. So it's also just not just about what happens when you die. A lot of us kind of think about going to our lawyer to talk about, well, if I die, am I going to go through probate? Am I not going to go through probate? All those types of things. It's important to remember that there's a whole lot of estate planning, especially the way that we practice it, that's about your life and what happens for the rest of your life, and making sure that you're prepared and you have the things in place for that. Things have changed. Things are not going to be just because this is the way that it worked for others. Maybe you've experienced this with parents, or even siblings or others, grandparents. You've seen your neighbor go through this, and what they went through might not be the same. And sometimes it seems like it went well, and in fact it didn't go well. Sometimes they just got lucky and didn't have bad things happen. And so one of the things is about being prepared for all aspects of this, no matter what happens here. So having said that, we're going to be talking about the difference between a will and a trust, and we'll spend some time on that because that's a frequent question that we'll have. And then we're going to talk about what happens if you die and what happens if you live. And one of the big issues here, of course, is not just the documents you need for death, but the documents you need for life. So we're going to go through those separately, and then we're going to give you an opportunity. You'll see at the end, Savannah's going to give you an opportunity to be able to get some one-on-one information and what you should do now, and how you can make sure that if you have legal documents that they're going to meet all of your needs. And then secondly, if you don't have them, now's the time. Let's get this done. We have an ability to do everything remotely right now, and so it's not only from a standpoint of the necessity of being able to do it remotely, but also the convenience. One of the things sometimes is it's very difficult to get in to see the lawyer and go through those processes. Well, right now, under our executive order with the governor, we have the ability to do everything remotely and do it at a little bit more convenient for you, so you don't have to drive into the office and all of that. So something to really give some strong consideration to is if you have been thinking about this and you need to get it done, let's get it done now. So let's get right into this. First, like Savannah said, there's a disclaimer. The disclaimer is just saying this is general advice. Obviously, if I'm doing a presentation to everybody, it may apply to most people, or it may be specific to most individuals, but it's not going to be specific to your needs. So everybody needs one-on-one planning, and you shouldn't rely on this as considered legal advice. That's where you need one-on-one conversations for legal advice. So starting off with, why do you even need to know this stuff? All right. So we talked about this, that it's not just about stuff. One of the things that's really important to remember here is that this is not necessarily intuitive. A lot of us think about this from the standpoint of, well, it can't be that hard. If I get sick, my spouse would just be able to do it, or my kids would be able to make decisions, or my parents would be able to make decisions for me. And the truth is, none of that's true. Okay, it's not intuitive. Sometimes we imagine that would be the case because, of course, that would be the case, but it's not. The law treats it differently. And you're going to see as we go through different aspects of medical decisions, or even access to information, or making sure your bills are paid if you get sick and those types of things, certainly what happens after you die, it's not automatic. It's not automatic necessarily that even assets necessarily go to the spouse. A lot of times it does, but we got to make sure, we got to go through each asset and make sure that that's the case. Certainly, it's not automatic that the kids can just step up and sell the house, okay? Are we going to have to go through a probate process? Are we going to have to go through something called intestate succession? That's a big word to basically say that the state has made a will for you. The state decided where your things are going to go. And so it's really important to know that this is not just an automatic, oh, well, we're all going to die, and so if we die, that's all just going to happen. No, it'll happen. It just might not happen the way you want it to happen. One of the things I find fascinating is we'll see this all the time with when a celebrity will die. Well, so with Aretha Franklin or Prince, or any number of celebrities that died, and when we find out that their estate was a mess, they might have been very successful and had all of this money, and now it's going to be going through the court system. Aretha Franklin's going to be going through the court system for years and years. Prince is the artist Prince is going to be, his estate is going through the system for a long time because things weren't set up thoroughly, and people just assume, oh, it's going to be fine. Well, it doesn't just apply to celebrities. It doesn't even just apply to rich people. We're going to talk about some documents that if you're over 18 and you have people that you love, and I think that's an important aspect of it, this is about the people that you love. So if you have somebody you love, that if you're over 18, there's some documents that everybody should have. And I rarely say that everybody needs this or not everybody needs that. I'll hear sometimes people will say everybody needs a trust. Well, that's not true. Not everybody needs a trust, or everybody needs a ladybird deed. That's definitely not true. There are certain things that are over sold or over talked about, and they actually will probably result in negative consequences if we are using them in a situation that's not ideal or situated for that person. But there are a couple things that, although they're not just form documents and fill in the blank documents, everybody really should have them after having thought about them, after counseling on them, making sure you understand what it is that you're signing and how important it is. But it is really important that certain documents like healthcare decisions, or who's going to pay your bills if you get sick or are confined to a hospital, or we had a call yesterday of somebody, their loved one is in the hospital and they're having a hard time getting any information because the hospitals are closed down and you can't visit and all of these crazy things that are going on right now, and they're having the hardest time getting any information at all. And it's very difficult for them because they can't be involved in the decision making for their loved one, and they're not sure if their loved one's in a position to be able to participate in that decision making? And if they don't have these legal documents in place, what's the answer? So what's the answer in a situation where they don't have these proper legal documents that could allow them to go to the hospital, call up the hospital and say, okay, I have this document, my mom, my dad, my sister, my brother, my parent, whatever it is, they have authorized me to talk to you, they've authorized me to make decisions, they've authorized me to get access to information. If we had that, in that particular case where the caller had called us on this, we would have been able to assist them to get through to the right people at the hospital and be able to not only get the right information, but make the right decisions, okay? Without that, what's the answer? The only answer is to run into court. Well, guess what? Most of the courts are closed right now, except for emergency matters. Well, this would be considered an emergency matter, but it's going to be messy and trying to get into court and trying to get an emergency order and things like that. And so ideally, we get this stuff in place before the emergency, before we're confined to a hospital, before some pandemic or whatever the scenario is. You know, these are important things both for ourselves to make sure we have things in place, but for our loved ones to make sure that they have those too, so that, I mean, God forbid, if your kids don't have these, you might even have these documents, but if the kids don't have them and they get sick and they don't have anybody that can be able to get access and talk to the doctors or nurses and be able to help make decisions or, you know, things like that, it can be a real mess. So it is not just about what happens when you die, and it's certainly not just about your dollars or your assets, okay? So things have changed, and I want to talk about this. I like that graphic, change versus chance. One of the things that people often will do is they'll say, well, this is the way my mother did it, or this is the way my aunt did it, or I saw my neighbor go through this, or my cousin go through this, and everything seemed to go fine. Or I've gone through this with my own parents, and everything seemed to go fine. And there's a variety of different things that I want to talk about there. First of all, a lot of the rules have changed, and especially when it comes to property tax rules and the property tax assessments and capping and uncapping of properties and how much you're going to pay in taxes and capital gains taxes on stocks and various other things that a lot of those things have changed. Certainly anything regarding retirement accounts, that's changed dramatically as of January 1st of 2020. What timing, huh? The estate planning as it relates to 401ks and IRAs and any kind of retirement assets, Roth accounts, all of those types of things was overhauled, completely changed as of January 1st, 2020. So we thought 2020 was going to be about scrambling to make sure everybody's documents are compliant with that new law. Who knew we were going to have all of this, right? And so we still have to deal with that new change in the law as of January 1st, 2020. But a lot of people, we just have to make sure they have their basic things in place right now under these current circumstances. So what worked for others might not work for you. The rules have changed. Even if things went really well, well, they might have gotten lucky. They might have had where some of the things that can be unexpected or some of the negative things just didn't happen in that case. Or it may have actually been more complicated than necessary. Sometimes people say, oh, well, it wasn't a big deal. We went through probate. Yeah, you know, I think it went on 8 or 9 months. Yeah, I had to go through this process and do all this paperwork, and I had this attorney, and it was all fine. Okay, you're right. That's not that terrible. Honestly, that's not that terrible. At the same time, wouldn't it be nice to make it easier for your family, make it more streamlined, make it so we have less court cost and less paperwork and less process and less time, and make it a much simpler process. So you might say, well, because a lot of times when after 2020 hindsight, we went through it and we say, okay, well, that was done, didn't seem that bad. You're right, it wasn't that bad, but maybe things went pretty smoothly and other things can come up. But secondly, wouldn't it be nicer to not have to have gone through that 8-month process or 9-month process, or whatever it is, or have it just kind of laid out a little bit easier for your family, having things set out in such a way that is going to make it so that less complications, minimize the complications. So even if there was no complications when you handled this for your mom, you can't say that that's going to happen for you. So let's get right into it. One of the big questions we always get asked is, what's the difference between a will and a trust? So I've got a couple of stories. I like telling stories. And what I mean by stories is analogies. I like to apply things to things that people are familiar with and do that. And so I've done a lot of teaching. I teach, there's a big thing that we do for social workers and those in the healthcare industry where we are helping them get their continuing education credits for social work and administering facilities and long-term care facilities and things like that. I also teach other attorneys. So every year I probably have 3 or 4 opportunities where I'm asked to teach to the continuing legal ed. So we have, in Michigan, we have what's called the Institute for Continuing Legal Education. And most lawyers, or hopefully most lawyers, will keep themselves up to date on different changes and new things and new practices. And I'm a pretty consistent speaker and presenter on those issues as it relates to estate planning and elder law and long-term care and veterans benefits and all those types of things. So several times a year, I'm having an opportunity to do that. So through the years, and I've been doing this for a while, through the years, I've developed some, I'm going to call them silly little pictures to explain the concept. So I'm a visual learner, right? I'm a visual learner. I like to see and, kind of dive into things. So I tend to be a visual teacher. And so that's where I've got these pictures to explain these concepts. And so the first picture that we have over here where it says option A, and we've got that funnel, right? So I like to call the will a funnel, the last will and testament. All right, what's the last will and testament? Well, first, when does the last will and testament take effect? Most of you are thinking when you die, right? Well, definitely, you're partly right. It does not take effect during lifetime. So if you have a last will and testament and you say, I've heard people sometimes say, I'm the oldest son and I'm the executor of the will, and therefore, even though mom's still alive, I have some say or I have some authority. Nope, you have 0 authority and you have 0 say. But guess what? You also have 0 authority and 0 say if you're the executor of the will and mom has passed away. Why? Because that authority under a will comes from a probate court. That's where the authority comes from. The will has no legally binding effect without a court saying that it does, saying it's the correct will, saying it's the most accurate will, saying it's a binding will, saying it meets the legal standards, and issuing what's called a letter of authority. If we have to go through that process and issue a letter of authority and look at the will, it is going to be a minimum of a 5-month process. Okay, the what's called decedent's estate through probate takes a minimum of 5 months. Realistically, in real life, most people, it takes somewhere around a year, 9 months to a year typically, to get through that process. Can't be done in less than 5 months. Under the court rules, it cannot be done in less than 5 months. Now, is there a way to avoid all that? Of course, that's one of the things we're here to talk about, right? I just want to be clear that if you're relying on your will, that's what's going to happen. Now, some people will say, well, wait a second, Bob, you seem like a smart guy, but I know you're wrong on this one. Well, I'm not wrong. Here's what I mean by this. Okay, the will is, we got to look and see whether it's legally binding. Some people say, well, my mom passed away. She had a will. I was the executor, and I never had to go through court. And what I'm telling you is you did not need that will then, and you weren't the executor, because you only become the executor or personal representative under the will if the court appoints you as such. The will doesn't have any authority on its own. You cannot take the will to the bank, that mom's bank account, and say, look here, here's the will, I'm the executor, give me the money. Can't do it. They won't let you do it. What they'll ask for is a letter of authority or a court order. So why is it that some people say, well, my mom died, she had a will, and we didn't have to go through probate? And the answer is because people use other techniques that avoid the will and avoid probate. But I want to be clear on that if we use these other techniques, then the will doesn't have any say in it. So sometimes people think mom will draft a will and then they'll put their daughter's name on the account. And they say, okay, well, my daughter's name's on the account so that she'll be able to administer this, and then she'll follow the will that says divide it between my 4 children. And the answer is nope, that has no legal binding effect whatsoever. Is daughter going to do the right thing and divide it among the 4 children? Maybe, maybe not. She legally doesn't have a requirement to do that. And secondly, it can create some issues for daughter, especially if it's any kind of retirement account or something like that, because it can cause her some tax issues by trying to do the right thing and dividing it up. She may end up having to bear the burden of most of the taxes on it. So there are some things that we can do to avoid probate. And so you see on my graph, or my picture here, it says, well, it only accounts for those things that go into the funnel. So I talk about the will as being a funnel. Why is it a funnel? It's a catch-all, but it only catches those things that need to be caught. So if it has a beneficiary designation or a transfer on death or a joint owner, or if it's in a trust, it doesn't need to be caught. So it's only for those things that don't have another mechanism of transfer. Now you see the funnel, one of the things we like about funnels, right? The funnel is, it says it's a catch-all. So anything that needs to be caught, that needs to be transferred, it will transfer it. And it'll transfer it down to where we want it to go. So great, that sounds good so far. People don't like the part where it has to go through probate, right? That middle section of the funnel, you see it's kind of in small writing there. If you can kind of see on your computer screen, it says probate. So that means that anything that goes through the will is going to go through this probate process. So then should we just use beneficiary designations or joint owners on everything? And so first of all, my answer as to whether or not you put your kids' names on the accounts is absolutely not. Do not put your kids' names on your house. Do not have a quitclaim deed that puts your kids' names on it. Do not put your kids' names on your investment accounts. They can be beneficiaries or transfer on death or something like that. That's not the best answer. It is an okay answer. It's not the best answer. We're going to talk about it. It's fine. We can develop a plan that involves a will and uses beneficiary designations and transfer on death designations and things like that. We're going to talk about whether that's a good idea or not, but at least that is certainly a better option than putting your kids' names on it as a signer or as a joint owner of the account. Now, a lot of banks, you go in the bank and you bring in your power of attorney, or you say you want your daughter to have access or something like that, and what's the bank or credit union often going to tell you? They're going to say, okay, no problem, we'll just put them as a signer on the account. What does that usually mean? What it usually means is that that child, that daughter, son, grandchild, whoever it is that you put on there, now owns the account. They own the account, and they can withdraw it just like you can. So that is often good for the credit union and good for the bank, because then they have no liability. No matter what happens, if something goes wrong, they have no liability. But it's not good for you. Why is it not good for you? Now, some of you are thinking, okay, yeah, I could understand why that would be bad for my neighbor. She's got a bad kid. You know, if she put her daughter on there, that'd be crazy because her daughter is crazy, but my daughter is trustworthy, right? Great. I'm assuming your daughter is trustworthy if you were going to put her on the account. You certainly wouldn't want to put anybody on an account or put them in charge of anything if you don't trust them, if they're not trustworthy. But do trustworthy people ever get divorced? Because if it's their money and they get divorced and the law treats it as their money, we could have a problem. Do trustworthy people ever have financial trouble? You know, where they lose their job? A lot of people lately, right? What if they can't pay their bills? What if they can't pay their credit card bill? Well, guess what? It's possible they could end up coming to garnish your account because their name's on it. So if they get a credit card, you know, the credit card company sues them and they get a judgment against them, they could garnish your account because their name's on it. What if they got sued? Somebody slips and falls on their property, or they get in a car accident for some reason it's not covered by insurance. Or what if they get sick? You know, sometimes we assume that everything's going to happen in the right order, that parents are going to get sick or parents are going to die before kids, but unfortunately we know that's not always true, right? So what if they got sick? Well, we got a problem because their medical bills could now be your medical bills. What if their spouse got sick? Guess what? Depending on some circumstances, their spouse's medical bills, your daughter's spouse's medical bills could now be your medical bills because your daughter's name is on the account. So putting names on the account is a bad idea. Beneficiary designations, transfer on death, payable on death, that's a better answer. It's not the best answer. Okay, so that's a will. So now I have the other side of the screen. We have option B over here, and they talk about probate avoidance. And with trusts, I like to call in my silly pictures, I call the trust a wagon. And there's a couple little stories as to why I call it a wagon. And the first story as to why I call it a wagon is because it's not a funnel. The funnel is a catch-all, right? It catches things and it directs them to where they need to go. The wagon doesn't catch anything, okay? So a lot of people, they pay a bunch of money, they go to a lawyer, they pay a bunch of money to get this wagon drafted, this trust drafted, and then they take it home and put it on their bookshelf and let it gather dust. The wagon doesn't work, the trust doesn't work unless we put the stuff in there. So if you look at a trust document, a lot of times people bring me this document and say, okay, here's my trust. Can you look at it and tell me if everything's going to go okay? And the answer is no, I can't. I can't look at the trust document, the typed up pages, and see if everything's going to go okay. What I have to do is I have to look at the deed to your house. I have to look at your bank account statement. I have to look at your life insurance beneficiary designations. I have to look at the life insurance who owns the account. I have to look at the investment accounts and see how those are titled and who the beneficiary designations are. Okay, so we have to go through each and every single account and make sure that those are either titled properly or have proper beneficiary designations to see if the trust is going to work properly. So in my analogy, and why I use this picture of the little red wagon, is we got to make sure that we're putting everything in the wagon. And we don't have to do that with a will. So some people say, well, will seems easier, right? Well, okay, it's easier at the beginning, it's harder at the end. So it's easier for you because you can just get it and put it on the shelf and let it gather dust. Well, the trust requires a little bit more effort on your part and a little bit more. Every once in a while, you got to make sure if you get a new account or you get a new house that you make sure it's titled properly, which we've got a mechanism in our office to do that. So I'll explain that. But it's a whole lot easier for your kids or your family if you get sick. And it's a whole lot easier for your family when you die, so they can settle the estate without having to go from account to account to figure out what we need to do for that account, or worse, go through probate. Okay, so the idea of the wagon is we do that. There's some work to be done with it. It's not just going to the lawyer and getting that done. Now we have a process in our office I mentioned to you. We have a process in our office because we noticed that I'm going to actually say the vast majority of people that have a trust don't have their assets all set up properly. They don't have their assets aligned with the trust. We call it asset alignment. And that's where they might have had it when they got the trust because they had the house, but they've sold that house and now they have a condo. Is the condo in the trust? Probably not. They might have had it where maybe, and often not, they put their bank account into the trust, into the wagon, but now they switched banks, or the banks switched on them and changed names or changed companies. Are we sure it's still in the trust? And the answer is we don't know until we check. Right? And what we found is with most people that come into our office, the vast majority don't have everything lined up right. So we came up with a plan, and most lawyers don't do that. They draft the legal document and they give it to you and then say, here, you go and do all this homework. And so we've got a couple options to make sure that it's more likely that you're going to have everything in the wagon and the trust is going to work properly. And that is that, first of all, we get somebody in our office that'll do it for you, okay? Sometimes these are relatively straightforward things. We give you clear instructions as to what to tell the bank and what to tell the life insurance company, and obviously we take care of the house and the cottage and all of that for you. That's all going to be taken care of through the law office. But we got somebody in our office who will get on the phone with the bank or get on the phone with the life insurance company or the investment company or your financial advisor or your accountant, and they'll make sure that everything is done. So we've got that option for you. But more importantly, or at least just as importantly, is we have this annual check-in for our clients. Now, there's no cost to this. We're not making you pay us every year. Unless you want to, and that's an option too. You can always have us check in every year, but for a lot of our clients, they don't want to pay us every year. So we have this annual check-in where we do this video, and we actually tape it live, so you can come and watch the video and come to the meeting, or you can just watch the video. And every year it's our way of kind of walking you through this sort of self-help approach. And we tell you about the changes in the law, and we remind you about how all this stuff works. But the big thing is then we ask you these series of questions, and there's a sheet of paper that we give you. And if you answer yes to any of those questions, then we're going to want you to turn that sheet in. Somebody from my office will call you, and we'll see, is this something we can just resolve over the phone, or is it something you need to come in and make a formal change? But we've got a mechanism just to make sure everything's up to date. okay? Because I don't want you to have it sit on the shelf for 12 years and gather dust, and then you say, well, I don't know if this is good anymore, and then try to find a new attorney and things like that. So our idea is once you have the estate plan with us, we're going to give you all of the mechanism and all of the ability to easily make it adjust to your life and make sure that it's going to work properly when the time comes that you become sick or incapacitated, or of course when you pass away, and that it's going to work the way it's supposed to. So we got this mechanism. We basically ask you to spend an hour a year with us, but that hour of year could be sitting on your couch watching the TV, or sitting in front of your computer and watching a video. And we do that every year to make sure that you have this check-in and process to make sure it's updated. Okay, so that's basically the difference between a will and a trust. All right, so then you can probably get where I tend to be on this, where is what do you do, what do you need if you die, or if your loved one dies. And so my tendency is, you probably have seen by the tone of my voice or some of the examples that I give, I tend to favor probate avoidance, right? I tend to favor a master plan over piecemeal, right? And so we're going to do whatever's appropriate for your circumstances. So if you feel like, well, I just don't have a lot of assets, or we're young enough that we want to make sure that we have things in place, but we're not ready to do a full master plan or a probate avoidance plan or things like that, that's perfectly fine. We still need to do those legal documents, make sure you have the basics in place. And we're going to go through, we have sort of that option A versus option B that we showed you here. Option A is, this is all the basics. So it's going to include your living documents, which we'll go through in a minute, your healthcare power of attorney, your patient advocate, your financial power of attorney, some other documents, HIPAA waiver. Option B is going to be a little bit more comprehensive, a little bit more inclusive, more of a master plan. My tendency is to want to have a master plan. My tendency is to want to keep it out of court. If we can keep matters in the family and keep the judges and lawyers and outsiders out of it, that's generally my goal. Now, some folks would say, yeah, I understand that, and we'll do that later. I just want to get the basics down. Perfectly okay. Whichever is appropriate for your circumstances, and we'll help you, walk you through that, and you decide what's best for you and your family. And honestly, the younger you are and the less assets you have, then sometimes we can just do the basic plan. Of course, we know under the current scenario and current what's going on in the world right now, we never know for anybody as far as youth and all of that. That's not necessarily something that we can guarantee is going to give us a long life, but it is one of those things that I think I have a tendency, my philosophy tends to be, let's keep things out of court, let's keep them family matters in the family, and have a plan for everything versus piecemeal. What do I mean by piecemeal? All right, piecemeal is what we talked about earlier, where it's not just whether you have a will or a trust. It's about, okay, people will often say, well, I'm not going to put this in the trust. Maybe they even pay for a trust. They say, I'm not going to put this in the trust because it's got a beneficiary designation on it, okay? Or I've got transfer on death, or I've got a joint owner, which is what I said you shouldn't do. And my advice is, no, look, if we're going to have a master plan, let's have the master plan. And so people often get confused because their neighbor or their sister or their banker or their accountant or anybody says, oh, you got to have your daughter's name on the account because you're past the age of whatever age they think is old now. And so that's counterintuitive to a master plan, right? So if you have a full, thorough trust, you shouldn't have to put your kids' names on the account. The trust will cover that. Even if you get sick, if you want them to help you manage your finances, or just want them to have access when you're on vacation, the trust covers that. We can have that through the plan. We don't need to put their name on the account. Putting beneficiary designations on there. Often that's not going to be the most thorough option either, because number one, it only covers things if you die. Beneficiary designations, transfer on death, that only works if you die. And sometimes it can lead to a lot more complications. You're going to see in a second how through a trust we can have some options to make sure that your kids are protected in the event that they're young, or in the event that they're going through a divorce, or in the event that they're have financial issues or medical issues, and all those types of things. There's a relatively straightforward and simple way for you to protect them. Can't do that with the beneficiary designation. What if the person you appoint as your beneficiary passes away? Well, would you want it to go to their kids? Would you want it to go to the other beneficiaries? Well, sometimes that's not always very clear in a transfer on death or payable on death. So when we're doing piecemeal planning, where we have a different plan for each asset. Life insurance has these beneficiaries, and the bonds have this transfer on death, and the real estate has this ladybird deed, or whatever the scenario is. And why I don't like that piecemeal planning is that we have to go to each asset and figure out what it is, but we also don't know that person. It's very now centric. And by now centric, what I mean by that is we're assuming nothing's going to change. That the only thing we're planning for to change is that you're going to get sick or you're going to die. But what if they get sick? And what if they die? We don't really have a backup in place. We don't have. It's not a thorough plan. It's a temporary plan. And how often do you update your beneficiary designations? Really? I mean, tell me the truth. Is it yearly? Is it monthly? How often do you check them? Most people that come in to see me might be every 30 years that they check their beneficiaries on their life insurance, if that. And it's one of the things that we insist that people do. We're going to help you with that process, but it's really important that we think about those things. And so people say, oh, well, this is easier. Well, is it easier? It may seem easier because you don't have to go see a lawyer or talk to a lawyer, but the reality is, do we want it to be easy to set up, or do we want it to be easy for your family? Do we want easy results, or do we want simple results, or do we want it to just seem easy right now? And my advice is we put a little bit more effort into it now so that it's easy for your family. We resolve those things, potentially resolve some conflicts, make it so that there's less likely that there be conflict, make it so that there's less likely that if bad things happen that we don't have a plan for that we don't have a workaround for that. And that's what a more thorough plan is going to do for you. Okay, so a few other things we're going to talk about here. What do you need if you die? We're going to talk about children, so adult children versus young children. So some people on the webinar today, their children might all be adults on their own, all those types of things, and some of you might have younger children. Well, with younger children, we've got a couple of issues. We want to make sure that they weren't going to inherit something at age 3 or at age 7 or at age 16. And particularly if that were the case, I'll tell you what happens. So let's say you list your kids as your beneficiaries on your life insurance or on your IRA or something like that. You list the kids as the beneficiary. Well, what happens if you're gone and they are still minors? They're under 18. Well, then there has to be a court-appointed conservator. So the court will appoint somebody to be in charge of that. Now they got to report back to the court and go through that whole probate process. Even if you didn't have anything else go to the probate, now we have a probate for the kids that are minors, which is bad. But there's something that's even worse about that. And what's worse about that is when they turn 18, guess what? They get it. If you had $100,000 life insurance, they get $100,000 at age 18, which you say, great, they're going to use that for college. I hope so. Our 18-year-old's great at making financial decisions and having the life experience to know that it'd be better to pay for college than that sports car. One of the attorneys in my office, she'll use the example, if it's an 18-year-old boy, is he going to use it for college or fireworks? Buy a bunch of fireworks for a great party, and so the idea is we really don't typically want them to get it at 18, right? That's not an ideal situation. We also don't want it to be managed or have to be supervised by the court through a conservator prior to 18. And so we really want to make sure that that's going to be planned for. Also with younger children, we need to specify who's going to raise them, who are going to be their guardians, and we can do that through the will. So the person that raises them doesn't actually have to be the same person that controls the money. And so sometimes we want somebody else to control the money. So we maybe, would want our sister to raise them, but maybe our sister's not so great with money, and we'd rather have our cousin or, our whatever. Maybe we'd want to, you get the idea that we might want to have different people in charge of different things. And sometimes there's some real value in that. So, we could set it up so that that money's available to them before they turn 25, before they turn 30, whatever it is, but they get some supervision, they get some help in making the right decisions about how to spend that money. This is particularly important when it comes to, retirement accounts and things like that, because they're also going to need some advice and help in deciding when to pay the taxes on IRAs and things like that. And there are options that are available for them. And that's where we get into some of the adult children questions. So what I call generational planning. And so there's a lot of different things that we can set up for them. One of the things when it comes to retirement accounts, we just mentioned this earlier, that the IRAs, 401ks, they dramatically changed the law as of January 1st, 2020, as it relates to these accounts and how family can inherit those. Okay, so it didn't really change that much as it relates to a surviving spouse inheriting. They can do a spousal rollover, but it changed quite a bit as it relates to the kids inheriting. And so there's not one bright line rule. People keep saying the bright line rule is, well, they have 10 years to pay off the taxes on it and to take that distribution. But that's not necessarily true. There's a bunch of exemptions to that 10-year rule. And we've got to make sure that your documents are planned accordingly based on who your actual beneficiaries are, how much money is there, what's involved. This is not a do-it-yourself project. And they have I'll tell you, there's all these websites you can get a legal document drafted on a website. And I tell you what, most of the time, over the years, let me just say it this way. Over the years, I've been paid lots of money to fix those situations. And it's not that the document was not legally binding. That's one of the things I hear them advertise on the radio and on TV. They say, well, these documents were found to be legally binding. Great. Did it accomplish your goal? Because most of the time it doesn't accomplish your goal. It might mean that you end up paying $100,000 in extra taxes because the IRAs weren't handled properly. And that's not unrealistic. If your IRAs aren't handled properly if you've got a $300,000 IRA or a $400,000 IRA and it's handled properly versus improperly, you might have a $40,000 tax over time versus a $100,000 tax over time, or sometimes $40,000 can be stretched out where it could be as even closer to zero tax, depending on the circumstances of your beneficiaries and a variety of other things. So this is not something a form document can help you with. What about protecting your kids in case they got divorced? Boy, I hate seeing this when somebody inherits some money and then the divorce judge includes that in the marital estate. They inherited it from mom and dad. The last thing mom and dad would want them to do is to have it go to that man that didn't treat their daughter right or whatever the scenario is. But I'll tell you what, in divorce court, that happens all of the time. Maybe it shouldn't happen. Maybe that's not the way the law is intended. But I will tell you, it happens all of the time. And so we've got these things we like to call generational planning. So I've got a quick example for you here. I was going to read you this little small print down here. It said the idea is the inheritance would be protected for the children for their lifetimes. They have access, but nobody else does, including from divorce, business failure, accident, nursing home, those types of things. So I'm going to give you a quick example. Let's say you have 3 kids, Susie, Roger, and Danny. And we got this 4th wannabe child out there. We're going to call him Sam or Uncle Sam, right? Uncle Sam wants some of your money too. And what we want to try to do is not make Uncle Sam our favorite child and make Uncle Sam the one that inherits the most. So we want to get as much as we can to Susie, Roger, and Danny, minimize what goes to Uncle Sam. We want to, we've got everybody treated equally, right? We've got some issues though. We love Susie, she's great. We just can't understand why she married that man. Our idiot son-in-law. Wouldn't it be great if we could make sure that Susie got it and there's no way he's going to get his hands on it? Or that if they got divorced, that he's going to get half of it. Or, even if they don't get divorced, that he's going to have access to it and spend it. We got Roger, and Roger was doing fine until he got laid off or he lost his business or whatever. Wouldn't it be great if we could get the money to Roger and it wouldn't be subject to his past debt? It wouldn't be subject to what we call his creditors and predators. Danny's a little different situation. Maybe Danny's on SSI disability. So maybe Danny was disabled or special needs from birth. He's on SSI. Guess what? If we leave him an inheritance, he might lose his medical benefits. He might lose his disability benefits. I've even heard attorneys say that we should disinherit Danny. No, we shouldn't disinherit Danny. We don't need to do that. There's a relatively straightforward way that we can make sure that Danny gets the value of his inheritance, that Susie can protect it from divorce, protect it from her husband getting his hands on it. Roger can protect it from his past debts, okay? And we call these lifetime protector trusts. So the idea is these don't come into existence until you die. But when you die, Susie would be in charge of her share. But as long as she doesn't commingle it with her other assets or with her husband and sets it up and keeps it the way that we set it up, she can invest it differently. She can buy a house, and now the house is protected from divorce. She can invest. She can take the money out and spend it. She can do all of these things and still protect it. Roger, the same thing. He could start a new business. He can have that money not subject to his old debt. Why is that legal? Because it's not technically in their name, right? It's still in this trust that we set up for them, and we can put Roger, who has basic control over it, and Susie has control over her share. And so we can do that. Now, Danny's a little bit different. So since Danny is on disability and medical benefits, we can't put him in charge of it, but we could put Susie in charge of it, or Roger in charge of it, or somebody else in charge of it. And that's going to allow us to leave the money for Danny and make sure that he has a place to live, make sure he has a cell phone, make sure he has some of the extras that aren't covered by his disability benefits or medical benefits, okay? There's some rules we got to follow with that, but ultimately we can make sure he gets his inheritance. So that's really important. All right, what do we need during lifetime? So who's getting the two issues really, right? Who's going to pay your bills and control your assets if you get sick? And who's going to make medical decisions, including life support if you can't? And so I put the signs out there. Should you put kids' names on your accounts? No, 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 no. You should not put your kids' names on your accounts. Obviously, between husband and wife, we can have joint ownership between husband and wife. That's perfectly fine. That's normal. It's expected. You know, a lot of times husbands and wives are going to be responsible for each other's bills anyway, and so that's okay. But anyone else, should you put your parents' names on your account? No. Should you put your sister's name on your account? No. If you're single, should you put your brother or your parents' name on the account? No. Should you put your kids' names on your account? We want them to have access, right? I understand. You want to say, I want them, if I die, I want them to be able to have access to that account that same day or the next day, right? I want them to have that access immediately. But absolutely, we do not need them to have ownership of the account. We don't need their problems, whatever problems they might have in the future, to affect our money. So we don't want them to be on the account, to be an owner of the account or on the account or a signature of the account. We want them to have access where they can control it if we're sick or on vacation or for convenience or we're deceased, that they have immediate control. We don't want them to have ownership. And by putting their names on the account, they have ownership, and it's a bad idea, always. All right. So these are the kind of the documents that we look at for lifetime. We've got the durable power of attorney for financial and legal matters, and we've got the healthcare power of attorney for medical decisions. Now, if we don't have a healthcare power of attorney and somebody needs to make decisions for us, we got to run into court and get a guardianship. If we have a financial need and somebody needs to pay our bills for us, we need to go run into court and get a conservatorship, okay? Now, we got to make sure that we have the right people in place. We don't want to give somebody financial power of attorney unless we fully trust them, right? On our documents, we actually often look at whether or not it's appropriate to give even extraordinary authority, extra authority for the person that we appoint under our power of attorney to be able to move assets around in case we go to a nursing home or in case we want to protect assets to qualify for Medicaid or qualify for veterans benefits or things like that. That's not in most people's powers of attorney. We do that because we help people at those end of life things. We help people with dementia. We help people qualify for Medicaid and help them with Medicare and veterans benefits and things like that. And if we don't have that legal authority, by the time they want that help, they need those financial benefits, they need some help paying for a nursing home, they don't want to lose everything to the nursing home. Well, it makes it really difficult if they haven't given sufficient authority to their spouse, or sufficient authority to their daughter or their son or whoever it is that they trust, right? And so our documents are a little different. So most people's powers of attorney doesn't have that sufficient authority. We call it extraordinary powers. And about 95% of the documents I look at when people bring me their existing documents, it doesn't have those extraordinary powers. And so we're going to have some issues in the event that somebody goes to a nursing home, trying to make sure that we protect them and protect those assets and don't have to spend down all of their assets. Okay. Now you see there's the lifetime circle and there's the after death circle, and then there's a little bit of overlap, and that's where these trusts come in. So the trusts are actually a lifetime document too. One of the things I always talk about a trust is, what is really a trust? Sometimes people think about it as, you know, trust versus will. So a trust is like a will. Well, it's a little bit more than just a will. So a trust is really just a contract between you and your family, or you and your loved ones. And it says, here's how I want things managed when I'm alive and well, if I'm incapacitated, and after I die. So what's going to be the rule when you're alive and well? Well, you get to do whatever you darn well please. There's no restrictions on what you can do when you're alive and well. We don't put restrictions on that at all. What's the rules when you're incapacitated? Well, it says who's going to be in charge and what their authority is, what they're allowed to do, what they're not allowed to do. And then, of course, what happens after your death? How are we going to distribute the assets? And are we going to provide any of those protections for the kids that we talked about on the previous slide? Okay. For your powers of attorney, sometimes you call them healthcare power of attorney or patient advocate or living will or all those different documents. Can that be one document? Can your healthcare power of attorney and the financial power of attorney be the same document? And the answer is no, they cannot. In Michigan, they cannot be the same document. There's different standards when they're used. There's different triggering mechanisms. And so you have to have two. You have to have one for financial and legal matters, and you have to have one for healthcare and end of life decisions, okay? Life support decisions. They have to be separate documents, okay? And they're both really important. Pretty much my view is, if you're over 18 years old and you have somebody you love, and I'm going to come back and explain have somebody you love, but if you're over 18 years old and you have somebody you love, you probably should have those documents. So even if you have kids, once they turn 18, they're not going to like it as a 18th birthday present, but they really should. It might be something you consider giving them, because guess what? If they're 18, something happens at school, you're not entitled to access to that information. Healthcare decision, HIPAA waiver. You know, you're not entitled to find out if they get in a car accident and they're in the hospital won't talk to you. You don't have healthcare power of attorney, durable power of attorney, and HIPAA waiver, and your kids are 18, 20, 21, whatever, they're not going to talk to the parents. Parents have no rights at that point. And so, although they'll probably not be thrilled when they open up the 18th birthday present that says, we're going to have you go to an attorney and get a power of attorney and healthcare document and HIPAA waiver drafted, it's really a great present. Honestly, it's a much better present than some of the other things that you could get them. They might not appreciate it at the time though. So, but it's something to think about, because it really is important. And why do I say, but only if you have somebody you love? If you don't have somebody that you love and trust, then we really don't want these documents. If we don't trust anybody, then I'd rather have it go through the court and have at least some supervision and oversight through the courts. I'm not a big fan of the court process. I think there's some overreach and some bad things that happen through the court process from time to time. But if we don't have anybody we trust, then I'd rather have it go that way. But if you got somebody you love and somebody you trust, I think those documents, everybody should have them. If you're an adult, you should have them. Okay. All right. So real quick summary: if you've planned, you have a durable power of attorney for healthcare. If you haven't planned, we might have to go to court and get a guardianship. If you've planned, we might have to do, we'd have a durable power of attorney for finances. If you haven't planned, we might have to go to court and get a conservatorship. All right, so I want to see if anybody has questions. I'm going to turn it over to Savannah. She's going to talk about any questions, and then I've got one other thing to talk about, and then she'll wrap things up here. So let's see if we have any questions.
Right now, I'm not seeing any questions in the chat box. So if you do have a question, definitely just put it in the chat and we will be more than happy to ask that question or answer the question.
All right, so.
All right. And it
All
looks
right,
like,
so I'm going to take over again for just a second, and then
yep.
Savannah will wrap things up. And my last point is, what should you do now? Okay, and this is really important. Is what should you do? I know that this is something that, especially when somebody sits through this whole class, they've sat here for an hour, that they say, yeah, I'm motivated, I want to get this done. I'll think about doing it tomorrow morning. I'll do it later. I'm going to get to that. I'm going to put it on my list. It'll be my next thing. My strong advice, knowing human nature and knowing how people do these things, is it really is a now kind of a thing. If you're motivated to do something, Savannah's going to talk you through some options where you can at least take the next step of inquiring. We've got some options where you don't have to commit to anything. Sort of a 15-minute phone call so that we can just see if we're the right fit for you and if we can actually help you, and if you can kind of interview us to see if we're the right fit for you and we're the appropriate, or it might just not be something that that your needs are not suitable for what we provide. And so we have an option for you to just kind of have a 15-minute check-in with us. Obviously, there's no cost, no commitment. And Savannah's going to kind of walk you through how to get that and send you a follow-up email. And then there's other options if you don't want to do the commit to the 15, but I strongly recommend that you take some kind of action now, just because I've noticed, I've been doing this for 25 years or almost 25 years now, and I've noticed how much people, they really intend to do it, they really want to do it, and then if they don't take any action forward, they put it off another year or 5 or 10 or never get to it. And it can put you in a real bad position. So like the Boy Scouts say, be prepared, get something done, move forward, take some action. So I'm going to turn it over to Savannah, and she's going to give you some instructions and kind of wrap things up.
Thanks, Bob. So just like Bob said, it's going to be really easy for you to get in touch with our team. An email went out to you probably about 10, maybe 15 minutes ago. And inside of that email, it has 2 options for you to get started. The first way is for you to click and actually schedule your own meeting with our client services specialist director, Katie. Katie's awesome, and she's going to talk with you for, just like Bob said, about 15 minutes just to talk about your concerns, and maybe just to see, if we are the best fit, and if not, we'll actually refer you to someone who is. So that first option is there. You'll click the button and schedule your own appointment when it's a good time for you. The second option is maybe you're just not sure if you would like an appointment. Maybe you just have a question or a concern, or there's just something that you want to know, or you just kind of want a little bit more information. In that case, there's another button. You'll just click that and it'll actually take you to our website, and you can just put your question in there and someone from our team will reach out back to you within 24 business hours. So again, that email should be there already in your inbox waiting for you. Tomorrow, I'll go ahead and send you the replay of today's session. Be sure to pass that along to friends, family, anyone that you think could benefit from the information we discussed today. Thank you so much for joining today's webinar. We're happy to have you, and I look forward to seeing you again next week.